One key principle of intellectual property law is that the courts and the legislators are in favor of not allowing copyright and design protection systems to simultaneously apply to an artistic work. This is referred to as the copyright and design law overlap, and is the focus of today's discussion. This prevention of dual protection is enforced through Sections 74, 75, 77, and 77A of the Copyright Act 1968 Commonwealth. It is important to note that this overlap only applies to artistic works, which includes paintings, sculptures, drawings, engravings, or photographs. Let's start with Section 74, which provides the definition of a corresponding design as visual features of shape or configuration, which when embodied in a product, result in a reproduction of that work. Using this definition, Section 75 prevents dual protection through removing copyright protection of a corresponding design that has been registered under the Design Act 1906 Commonwealth. For example, if an artist created a sculpture and then made a lamp using the sculpture's form, this would be a corresponding design. But if the artist wanted to then mass produce these lamps, he would need to register the corresponding design under the Design Act to protect it. However, the sculpture would then no longer be afforded copyright protection. The issue here is that design protection lasts 16 years, whilst copyright protection requires no registration and extends for the life of the author plus 70 years after, so it is in most cases superior. This then raises the question, why doesn't the artist just not register for design protection and rely on the copyright system to protect his design and let him mass produce the lamps? The answer to this question can be found in Section 77, which removes copyright protection on a corresponding design when it is industrially applied. Whether a corresponding design is industrially applied is a question of fact, but there is a presumption in the Copyright Regulations 2017 Commonwealth, Section 12, subsection 1, which states that applications to 50 or more articles is an industrial application. This means if our artists produce more than 50 lamps, then the design would no longer be afforded copyright protection. Therefore, it is crucial that artists register the design beforehand if they wish to industrially apply it, as otherwise they will have no legal ground to sue if someone embodies a design in another product. As you can see, the provisions of the Copyright Act are there to make creators or owners of copyright decide whether their works are for artistic purposes and therefore should rely on copyright protection, or for more commercial purposes to reproduce their works in numbers, and therefore should rely on design protection. The reasoning behind this is because design protection is thought by courts and legislators to be more appropriate for the industrial applications of design, because design protection already awards creators a monopoly, so it would be unfair to also allow copyright protection. But what do you guys think? Comment your opinion below. However, there are some exceptions to the copyright and design overlap. For example, copyright protection is not lost when a 2D artistic work is applied to a 3D article, such as a painting printed on a t-shirt. It is only when a 3D design is embodied in an article is copyright protection lost. Additionally, copyright protection is not lost when works of artistic craftsmanship are applied industrially. These works must involve a degree of artistic quality and craftsmanship. An example of this could be a unique piece of furniture. Therefore, even though it is mass-produced, it still retains copyright protection. Well, there you go, guys. There's an overview of the copyright and design law overlap. I hope you learned something today, and thank you for listening.